I might just emphasize one point. It applies to contracts, not negotiating.
Right.
So there is no actual obligation to negotiate in good faith.
Hey everyone, it's Lawrence Mack from Remax Realty. I'm here with Brian Madigan from Remax West. He's a real estate broker as well as a lawyer, and just wanted to ask him a few questions about a very important ruling. So Brian, there's been a myth out there that people can get out of a contract because of a line in the clause that says sole and absolute discretion. Specifically, people have used this both in financing and in the inspection clause to say, well, it says sole and absolute discretion. So because you don't like the flooring or because the fence is oily or squeaky or whatever, we're going to get out of this contract. And I guess the question to you is this true?
Well, it certainly used to be true. It was true until a recent case in the Supreme Court of Canada, referred to as Bhasin and Hrynew, the 13th of November, 2014. And the court basically at that point in time said, we're changing the common law. That's not fair anymore. Mm-hmm. So that was a very important decision which they made. One of the things that they said, and they directed everyone's attention to, was the fact that they were changing the common law after hundreds and hundreds of years being the other way around. Namely, mm-hmm. Yes, it was a free walk. But now they have come up with the proposition that there is an obligation of good faith contractual performance. And secondly, a duty to act honestly in the performance of one's contractual obligations. And so those are the two new principles that are there in contracts, which eliminates the opportunity to simply walk away once one has signed an actual agreement of purchase and sale.
Ah, I see. And then the actual ruling was made in 2014, right? But the original, I guess, breach of that particular problem was done in the year 2000. Is that true?
Yeah. So the activity that gave rise to the problem in the first place, that was in contention, actually took place in June of 2000. So the interesting thing is this process of litigation took 14 years for the court to come along. And their pronouncement actually was, what was the law in June of 2000? Mm-hmm. All right, so, but no one knew about it until finally the Supreme Court of Canada came out with a pronouncement 14 and a half years later and said, this is what we have concluded. So that one important thing is it applies to all contracts mm-hmm. across the board. There aren't any exceptions. Unless the only ones that would be exempt from the ruling would be those where there was already a good faith obligation. Insurance contracts, for example. Mm-hmm. So that good faith obligation would have been in historically and also as part of the common law. But this is adding it now to all. It used to be that you had two choices with a contract. And this was set out in a decision by Mr. Justice Wendell Holmes in the United States Supreme Court back in the 1930s. And he concluded that you had two choices with any contract. You could perform it, in which case that was appropriate, that was what you were expected to do. Or you had a second choice, and that was to breach the contract, but your corresponding duty was then to pay the damages that mm-hmm. had been sustained by the other party as a result of your decision to breach. The Supreme Court of Canada has taken away that second choice. That second choice of breaching the contract isn't there anymore. The expectation is that you will perform the contract. So in this particular case, and we're looking at, for example, inspection and financing, it's expected that you will conduct an honest inspection in good faith. So you can't simply withdraw or not perform the inspection at all. And when it comes to financing, if you are under an obligation to seek out financing. Mm-hmm. So that may be making an application to more than one financial institution and having more than one financial institution reject you if you are not proceeding with that contract.
Right. So what you're saying then is if you have only a financial condition in your offer, the only way you can get out of that contract is by having a financial issue. And even then, you can only get out of it by trying, like, I guess, your best attempt at trying to fulfill that particular condition in good faith.
Absolutely. One thing which is an interesting wrinkle to this would be, let's say you were entitled, or you thought that you would qualify for a $500,000 mortgage. As it turns out, your bank has told you, no, you now only qualify for a $450,000 mortgage. The result being you're short $50,000. You should propose reasonably to the vendor and provide the vendor with the option of taking back a vendor take-back mortgage for $50,000. Now, the interesting thing is that would have to be at first mortgage rates,
right,
not exorbitant second or third or fourth mortgage rates, so that you're in the same position as a buyer, but you would have two mortgages. Now, that's something which forces you to come to the table. The Supreme Court of Canada is essentially asking you to do that. That reasonably speaking, if you were interested in going ahead with the transaction, that would be something that you would do. So what you now, in terms of thinking about withdrawing from the contract, you need to have a paper file which will demonstrate that you've taken every reasonable step to complete the contract. So the old opportunity to just breach it and walk away and pay damages is no longer there.
Oh, I see. Anything else you'd like to add about that, or that's pretty much it?
No, I think that's probably it. Good faith contractual performance is in, and absolute and unfettered discretion is out. I might just emphasize one point. It applies to contracts, not negotiating.
Right.
So there is no actual obligation to negotiate in good faith.
But once you have a contract going,
absolutely,
then you've got to fulfill the contract.
As you've set out in your contractual agreement.
Goodwill, you want to keep moving forward until that contract's done as best as you can.
Yes.
Excellent. Well, that's Brian Madigan for you, real estate broker at Remax West and also a lawyer. If you have any issues and you need help with real estate expert witness testimony, give Brian a call.
Thank you.
Thanks.